This Honorable Court of Appeals of Tennessee is now in session.
Good afternoon. We're having a little problems with Mr. Meldorf's camera, but we've discussed it, and what we're going to do, and he's agreeable with this, is he can see everyone. We just can't see him.
This is super. Oh, but there his camera just came on. We can see him perfectly fine on YouTube.
Yes, we see him now.
Okay, great.
So what I was about to say, never mind. If we have any additional technology related problems, everybody just take a deep breath and we'll pause and work through it. Seems like we're up now. All right, we'll hear from the appellant.
Your Honor, can I call the case?
I'm sorry.
I'm going to call the case if that's okay.
Yes, I'm sorry. See, you threw me off my rhythm.
It's Katherine D. Morgan versus Kenneth F. Morgan, Jr.
Thank you, Mr. Hefner. Now we'll hear from the appellant.
Good afternoon, John Konvalinka on behalf of Kenneth Morgan. So with regard to this particular case, it's somewhat fact intensive because essentially we are submitting that the lower court made erroneous findings of fact, which are not supported by a predominance of the evidence in connection with a number of factors it used in determining the best interests of the child with regard to the parenting plan. We do have a legal issue as well with regard to the use of the expert, Dr. Hillner, in connection with his testimony. So I will attempt to address both of those. Unfortunately, this is fairly fact intensive, and I'm not sure I'll get through all of the argument in 10 minutes, but I will attempt. With regard to the first factor that the court made a determination on is the court made a determination that the mother had a closer relationship with the child than the father. The history of this case is these parties were married in 2010. They separated in 2012. The child was born in 2013. A divorce was filed in 2015. With regard to the arrangement after the divorce was filed, there was some period of time in which the mother was denied some residential time. And then there was essentially a plan adopted where she would have supervised residential time. And then that supervision restriction was lifted. But from the period of time, essentially from 2015 until the decision of the court, the parties alternated 48 hours. So they spent 48 hours on and 48 hours off. So they had a substantially equivalent time prior to the entry of the order adopted, the memorandum of order changing the parenting plan. And so with regard to the closer relationship, one of the factors that the judge relied upon in making his determination was that the mother was spending more time with the child than the father. We submit that that is erroneous. The father had in fact started his own business with his new wife, and they had purposely set up where he could be flexible in his time so that he was available during his 48-hour shift that he had the child. And so they both had a good relationship with the child. In fact, one of the experts in connection with this case, Dr. Hillner, he actually, even though I may take issue with most of his testimony, he actually recommended that there be equal time. And the judge relied heavily upon his recommendation with regard to the designation of primary residential parent. But at the same time, Dr. Hillner said they should have substantially equal time. Haiti Perez said the same. With regard to the guardian ad litem, I will tell you that initially in January of 19, when she promulgated or adopted or submitted a permanent parenting plan, she had a substantially equivalent time. There's been no real explanation from January to July of 19 when the guardian ad litem changed the plan that she had submitted so that he would only have time from Thursday until Sunday.
Mr. Konvalinka, that was going to be one of my questions is, did the guardian ad litem ever explain then why she changed the parenting time from equal time to not equal time?
She did not.
Okay.
what I would submit to you. The record does not demonstrate that. All we have is a parenting plan that was done. It is obvious that, you know, in connection with this, Mr. Morgan at some point in time suggested to the court with other counsel prior to me that the guardian ad litem was spending what I guess referred to in my brief as robust communications, over 200 communications between the mother and the guardian ad litem, and with only one communication with the father, when the father had made repeated requests for interaction with the guardian ad litem, all of which is documented in the record. That's the only explanation I can tell you, is that there apparently became a more of a relationship between the guardian ad litem and the mother than there was with the father. That's the only thing I know factually. There's been no other evidence introduced to suggest otherwise.
The counsel, can we tell from the those communications, said over 200 between mother and the gal, can we tell who initiated the various communications, who
Yes, you
started the
can.
conversation, I guess?
Yes, you can. You've got email communications from the mother and email communications from the guardian ad litem.
In response to the mother's?
In response to the mother's, actually, where she's actually saying that she should talk to her own lawyer, but we submit that not only she goes farther than that, and they start talking about how to approach certain questions and how to approach certain things in connection with the lawsuit. And that was one of the reasons that Mr. Morgan suggested to the court that she had become biased and wanted her relieved, and he made that request at least on 2 different occasions in connection with this. But again, back to the original question of, you know, why is there a change? We don't know, because we never were explained with regard to the change in the parenting arrangement by the guardian ad litem. But back to what the court did is with regard to that factor, they said that the mother had more of a stronger bond with the child because she was homeschooling. Again, the facts are the mother lived in Hamilton County at the start of the divorce. She unilaterally moved from her parents and other family members here in Hamilton County to McMinn County with the child without notification to the father. She then became married shortly thereafter, and she decided unilaterally to homeschool the child. Again, Dr. Hillner said homeschooling the child would not be good. Dr. Hillner said it would not be good for them to have different other than substantially equivalent time. He did suggest that the mother would be a better designated as the primary residential parent in connection with this. The second factor that the judge somewhat relies upon in connection with this that we submit is also erroneous, is that he says that the father was not going to foster a relationship between or promote the relationship between the mother and the child. We have cited to you in the record in exhibits, not as well as testimony, demonstrated that Mr. Morgan was interested in fostering a relationship. And we also have demonstrated in the record, the mother's attitude towards the father, where she doesn't even admit that he loves the child. And so again, with regard to that, with all due respect to the lower court, we disagree with his finding on that particular issue. He seems to rely quite a bit on Dr. Hillner for certain things, i.e. the primary designation. I will tell you, we have a fairly significant issue legally with Dr. Hillner. He was given a court order by the original court, the Chancery Court, that he was supposed to be doing an evaluation of the 2 parents, but not do a comparison. And there's a specific order with regard to that. In fact, there was a concern actually on behalf of both parties, and they actually filed a motion with the Chancery Court asking the court to remind Dr. Hillner, because he had advised him he was going to do something different, that he needed to follow the court's order. Regardless, Dr. Hillner did not follow the court's order with regard to that. And he chose to do a parental evaluation, and he chose to do a comparison, and yet he was allowed to testify even though he had not adhered to the court order and over the objection of Mr. Morgan's counsel. And specifically, there was also a decision made that he was not going to testify before the parents, so it would not prejudice the judge's thought process in connection with this. That didn't happen either. It actually happened during the dependency and neglect portion of the hearing. The hearing was actually delayed for several months after Dr. Hillner testified. So that testimony was already out there and in the judge's mind at the time he did it. And the other issue that became apparent is that, in fact, the counsel for the mother had engaged Dr. Hillner to, again, testify on behalf of the mother with regard to not only Haiti Perez, but against the father. We've given you a quote from in a statement from counsel with regard to that in our reply brief. And so, again, that is another issue in connection with this, with regard to that particular expert and his failure to not only adhere to a court order, but it's a failure to adhere to the American Psychological Association rules, which require him not to be doing a multiple representation or engagement with people when he is doing an evaluation. And I'm about out, so unless someone's got a question.
I hear none, so you have your time for a vote. We'll hear from counsel for the appellee. You need to unmute your computer. Mr. Miller, if we still can't hear.
Thank you.
All right,
Can you hear me?
there you are.
May it please the court, I am John Meldorf. I represent the appellee and the counter appellate in this case. Mr. Hivner's timer has frozen, as have your pictures. So, Mr. Hivner, I have no idea when my 15 minutes is going to expire, and I just wish to alert the court to that. Can everyone hear me?
Yes, we can hear you. It looks like your photo's fault has frozen with us, but the timer's working. We can see. I'll advise you.
All right, thank you, Your Honor. May it please the court, this, as we all know with all primary residential care cases, this is a fact-driven case. The law suggests it should be a fact-driven case. The statute lists numerous criterion upon which to determine who should or should not is going to be designated as the primary caregiver when the court must do that. And the court did that in this case. Our brief contained 22 pages of facts, straight from the record, all cited, in which we pointed out all of the problems, all of the errors, and all of the facts that the court we felt should have and did rely upon. Not a single one of those facts on which are cited in 110 footnotes over those 22 pages, not a single one of those facts was denied or refuted in appellant's reply brief. So they're facts. Facts like refusing to surrender the child at the end of the parenting time, tape recording and cross-examining the mother one time for 1 hour and 8 minutes while the child was waiting inside when the mother had come to pick up the child, refusing to communicate with the mother about such things as baseball schedules, school schedules, submitting documentation not once but twice for daycare in which he listed his new wife as the wife, and he put down as people not to be called in the event of emergency and not allowed to pick up the child. He listed who the actual mother of the child. All of this are in those 22 pages. Every bit of it was taken into account by the court, and there's no question about it that the father had no interest in fostering any kind of relationship between mother and child. As for what happened between January and July, to answer Your Honor's question as to perhaps a change in the guardian ad litem's outlook on this case, between January and July, we had, number one, a suspension of the proceedings and a filing of a dependency and neglect case, the fourth dependency and neglect case in this case by the father, filed between January and July of 2019. We had the McDonald's incident, which the court remembers from our brief, where the child allegedly made some statement about being dangled over top of the balcony at his mother's home by one of the stepsons or two of the stepsons. And yet, though the child continued to reside every 48 hours with the mother, the father for over a month never disclosed what it was. He wanted to insist that the mother should instead meet with the child at McDonald's and let the child tell him, even though both psychologists his own psychologist testified that was clearly not the thing that he should have done, and she did not recommend that to him whatsoever. We had the second daycare incident where he enrolled the child under the stepmother's name, as I pointed out. We had another baseball season in which he did not forward the schedule, nor did he come over to Etowah and visit any of the boys' games there, although the mother continuously went to the Hickson Middle Valley in Chattanooga to see the boys' games, as well as attend his various activities at the daycare. And finally, we had that horrible situation where the child made a collage of his family at the daycare, and the father refused to give any pictures, paintings, photographs, or anything of any of the mother or any of her family. The collage was only of him and his family. All of those sorts of factors all came out between January and July 2019, just to list 5, okay? And it's little wonder that the guardian ad litem chose to make a different position in this case. The parental evaluation, I want to point out that, yes, Dr. Hillner went beyond what the Chancery Court had originally ordered, but he also explained that this was because that was part of the parental evaluation process. And although there was an objection to Hillner testifying, not once but twice, when Hillner actually testified about his parental evaluation, there was no objection raised by opposing sides. So they have waived that, okay? They still, even though they had objected and it had been ruled against them that he somehow had some prejudice, they still could have objected to the extent of his testimony when he started talking about parental evaluation. But they did not do that, and in fact continued to cross-examine him about that parental evaluation. Now, as far as the allegation that Hillner did something wrong, the court had 3 hearings on this. A motion in limine after I amended. Yes, Your Honor?
Sorry to interrupt you, but Mr. Hibner, the clock is frozen on mine now, so I don't really know where we are on time.
Okay.
Is that correct now?
All right.
Is that right?
Yes, Your Honor, that's correct now.
All right, I'm sorry, Mr. Miller. Go ahead.
Now the ACA, nowhere in the brief or in argument today have we ever learned anything that the ACA addresses as regards Dr. Hillner's activity. In fact, the only law that they provided in their brief had to do with dual relationship, where an evaluator later became a therapist for the child, okay, which is a clear violation. In fact, his own psychologist, Haiti Perez-Pera, acknowledged that fact and agreed that it was scholarly. The Greenberg-Schumer article, which I introduced in evidence, was a scholarly article, and she agreed with his conclusions about that kind of a dual relationship as being unethical. She admitted it even though she was doing it herself. But in this particular case, there is nothing in the ACA. It talks about multiple relationships. It doesn't identify what those relationships are. And the only ones that opposing counsel has listed are the ones where an evaluator later became a therapist for the child. In this particular instance, Dr. Hillner, of course, the court saw, because it was in the record, the amended expert interrogatory answers where I had proposed additional questions for Hillner. The court ruled that they could not be asked, and that was the end of it. Hillner himself testified that the questions I had asked him were not a violation of the ACA. That was part of the judge's finding. That's cited in the brief. And so there's no question that just the mere fact that I had spoken with him beyond the scope of his original report, which we got to remember was over 2 years in advance, of course. That was not a basis under the ACA for any allegation. And the judge ruled not once, not twice, but 3 times that it was permissible for him to go ahead and testify, so long as he did not go into anything that I had talked with him apart from that. And it's important to note that when you look at the direct examination, which is in the record, he went through his report from, at that point, 3 years before. He did not go beyond that report until cross-examination, when opposing counsel asked some of the underlying information, some of the tests he had performed, some of the notes that he had received from or some of the notes he had written that he didn't testify from directly on direct. There was nothing at any point that went beyond, in his testimony, that went beyond the scope of his report and recommendations, excepting, of course, what I just mentioned. Now, as far as those recommendations go, we have to remember that he was an expert witness. And I respect counsel. He's a good friend and an excellent attorney. And in his brief on page 38, footnote 270, he cites clearly an excellent decision of the courts, which points out that the trial judge may utilize some, none, or all of the information received from expert witnesses in making a decision. In this case, we have a very experienced trial judge who, over his 16 some years now, has tried many family law cases, knows clearly what he is doing. That's part of his jurisdiction as a circuit court judge. And he ruled that in this instance, he did not have to follow, and I mean, he didn't have to rule it because he understood the rule of evidence on expert witnesses. He did not have to follow lockstep everything that every expert had to say to him. He utilized his own judgment, and I think that that was good judgment. Even if this court, for some reason, I will argue as the opposing advocate, even if this court decided for some reason that Dr. Hilner should not have testified, remember that under the rules of this court of appellate procedure and the rules of law in general, there still has to be some reversible error that resulted from that testimony. All right, so let's assume for a moment that Dr. Hilner should not have testified. You could throw out the entire report, you could throw out that entire testimony, and look at the 22 pages of citations of all of the things which the father did to try to disrupt the time of the child and the love of the child with his mother. And the trial judge can look at those facts alone and say, there is my basis. And in fact, he seemed to do so in his detailed memorandum opinions. There is my basis for finding that it is highly unlikely that the father is going to foster a good relationship with his child if I make him primary residential caregiver. That's the important thing there that we have to remember. If the court does not have any additional questions on what I have addressed so far, I would like to take a moment and address my cross appeal, if I may.
However you choose. You got 3.5 minutes.
Thank you. Starting on page 45, I believe, of my brief, and specifically footnotes 238 and 239 on page 57. Mr. Konvlink is one of his prior counsels. Both parties actually had, Mr. Konvlink is the third attorney in this case, as you've noticed. Mary Sullivan Moore, 32 days before the trial of the case, filed an affidavit alleging the source of an injury to the child back some 17 months prior when the child was 2 in December. Okay. That I moved to strike it because what it was in essence was an amendment of the expert witness testimony, and therefore we were ready for trial, and the last thing I wanted to do was go ahead and get the trial delayed. We were all ready to go. 4 days before trial, the court finally ruled that no, they were going to allow this person to speak to the child and do some investigation on the child. A non-licensed, I should add, a non-licensed family psychologist who has, as of the time of trial, never even sought to get a license. But the fact remains that for 2.5 years, we had a delay. We had to take her expert witness's deposition 3 times. We had to prepare for trial a couple times. The expert witness wouldn't give opinions, so we had to go to court and get either a motion striking her testimony or compelling her to give opinions. Further delays, And not once but twice, I filed at the close of the DNN hearing and at the close of the final hearing, I filed motions under Rule 26. It is clear from the footnotes that I cited and in this matter that the that the opposing counsel at that time had not spoken to the witness, had not employed the witness as an expert witness, had not employed the witness, period. That the witness did not know that she was claimed to be an expert witness. She had not seen the proposed interrogatory answers nor approved them. She did not even know any expert interrogatory amended answers were going to be filed, and in fact did not even see a copy of them until over 4 weeks afterwards, when the guardian ad litem herself provided a copy to her.
You have about 40 seconds.
All right. So it's our feeling that the tremendous cost between those two trials was a direct result of the actions in direct violation of opposing counsel of Rule 26 in delaying this case. And for that reason, she should be cited and we should receive a judgment under Rule 26 for benefits. I'm concerned that the court didn't rule not once but twice, didn't put down any ruling at all, but I respectfully suggest to the court that the facts are all there, they're undisputed, and this court can go ahead and provide the relief that my client is entitled to under Rule 26. Thank you, Your Honors, for your time.
Thank you, counsel. We'll hear from the counsel for the appellate rebuttal.
With regard to counsel involved prior to me, Your Honor, I would just say it is interesting, the observation of the lower court with regard to the conduct of not only her, but Mr. Meldorf, in that he attributes fault to both of them for being contentious and being in his courtroom every Monday and not agreeing upon orders or consulting with each other. He faulted both of them. And in fact, when there was a request for attorney's fees in connection with this matter, he said the fees that were generated by the two of them were unreasonable in connection with this matter and gave him a reduced award with regard to those fees as the prevailing party. With regard to the 22 facts that he has listed, I would encourage you to look at the record. We say at the beginning of our reply brief fairly quickly that most of what is stated is incorrect and is not supported by the record. I can give you examples with regard to that, but again, I know the citations, I would encourage you to look at the citations in connection with it. There is essentially maybe a kernel of truth within that citation, but in large part, it does not support the fact that is being stated in connection with this matter. With regard to this particular case, again, with regard to, there's never been an explanation as to why we had to go from an equal time to a substantially unequal time in connection with this. There's never been an explanation as to why homeschool would be preferred as opposed to what all the experts, what the testimony was of but both Mr. Morgan and even the school teacher that showed up to talk to the child, who was not allowed to actually give a progress report, which I've objected to at the time, and it's also cited in my brief as an error in connection with it. Again, it is obvious that even Mr. Hillner, Dr. Hillner, suggested that the child would benefit from a traditional school. And he also thought being disparate after having such a long time as being substantially equal would throw gasoline on the fire, if you will, and also confuse the child in connection with why he's not able to see each parent similar to what he did before in connection with this. Again, with regard to Judge Hollingsworth, again, there is some degree in the reply brief, in the appellee's brief about abuse of discretion. This again is not an abuse of discretion standard. This is a presumption of correctness unless the preponderance of the evidence suggests otherwise. And I want to make sure I address that because there's a suggestion that there's some type of abuse of standard, even in the question that is propounded with regard to the first issue in the appellee's brief. In connection with Mr. Morgan, again, what he was concerned about and what happened in 2015 is that there was this accident that happened where the child's middle finger was amputated, and that changed the whole complex of this whole litigation. The parties had agreed in connection with pretty much everything at that time. It was after that occurred and there was a change where she had to have supervised residential time, and then it was ultimately lifted in connection with this. There also is, I would say, given short shrift by the judge in the sense that he didn't prove his abuse allegations by clear and convincing evidence because he didn't. We have a 2-year-old or less than a 2-year-old in connection with this. But there was obviously evidence of spanking, aggressive spanking. We had 2 different pediatricians make a referral to the Department of Children's Services because of what they saw with regard to what was physically on the child, either fingerprints where obviously where somebody had grabbed the child or had been aggressively spanking, together with the amputation of the actual finger itself that no one has yet ever explained. Again, yes, the father was vigilant. Yes, he was taking lots of pictures. Yes, because the Department of Children's Services says you need to document this so we can do something about this. You need to take it before and after. And that's what he did. And that's when he captured actually the spanking as well. And so again, the father was being very vigilant with regard to the welfare of the child in connection with this. Yet at the same time, he's also communicating with the mother about his events that he has going on with the child. And I'm out of time, and I apologize for that.
Thanks to counsel for both sides. We appreciate your briefs and your oral arguments in this. Mr. Hebner, if you'll adjourn court till tomorrow morning. You're muted. You need to unmute, Mr. Hebner.
Goodness gracious. This honorable court is now adjourned for the day.